I'm back. I'm back, guys. Sorry. I get cut off. I need to figure this stuff out. It's October 29th, 2017, Sunday afternoon, and this is Amelia Duran, your host, Porthole to Justice, the window to the truth. And I am... Are you there, Lotus? Are you there?
Yeah.
Hi. Okay, wait a second. Yeah.
I don't have a video of you, but that's okay.
Yeah.
I don't have you on video, but
yeah, you know, my stuff's been doing some kind of funny stuff lately.
Imagine that. Are you live? Are we live?
We're totally live. This is Lunch with Lotus, Sunday on Porthole to Justice.
Hello, how's everybody?
We miss you.
It's been a while.
We haven't had our
It's been a long while. We've been very busy. Ray is out of incarceration and unlawful incarceration in prison, so we kind of hit the ground running on that. We've been doing some things and working with the circuit court, and so I'm glad that we touched base a couple days ago because we'd like to update you on that whole little debauchery.
News. That's great news. So
but,
is she joining us? Is she joining us today?
Well, she's sitting right here. I don't know if she'll join us, but she's definitely sitting right here. So I checked the circuit court. I think we talked to you. We're actually in the 6th and the 7th Circuit. And in the 7th Circuit, we moved over to the state of Indiana, the corporate state of Indiana, because basically the state of Ohio and the district court had barred me from operating on behalf of Clay and Ray, even though I was appointed counsel, and barred us from entering any more pleadings in the district court. And so we're basically clearly. When
you say bar, can you define barred?
Oh no, but the administrator for the district court barred the clerk from taking any pleadings from us in the district court for the state of Ohio. Yeah, they said that, yes, and that all our pleadings would be deemed moot if we did any. So because they had no other course, because we were clearly showing treason and sedition upon the record, and they were trying. And as I've told you all, these are not courts; these are administrative banks that have been set up on behalf of the international criminal organizations of the Pope and the Queen to steal our state's chattels again, just like they did before 1776.
And they're creating
their agents are here routing and eating the substance of the people again. And they have set up a false judiciary who are merely administrative trustees of our international Susquehanna trust accounts. And they're posing as courts. And they're not courts. They're international bodies of bankruptcy that are operating outside of due process of law and outside of the law in general, not in compliance. They on the face of it, they like to pretend that they are courts, but they're not courts. They're banks. So we had all of the state of Ohio banks, the county, quote, court, the appellate court, quote, for the county, and the Supreme Court, quote, for the state of Ohio, all operating in conspiracy against rights. And actually, they had dismissed a writ of habeas corpus for a child, saying that I was not an attorney and could not file a habeas corpus for a child unless I was an attorney, which is a complete violation of the law and an act of treason and sedition. And that was on the record. And we went to the district court and looked for remedy there at law, pursuant to Section 16 of the Judicial Act, and were denied remedy at law with the district court, who actually defamed me and impugned my character and insulted the claim, and denied Clay remedy and relief, and denied Ray remedy and relief, and barred us from putting anything upon the record. And we're acting incredibly prejudicial. So when you get to the district court, which is, and so the circuit court, the 6th Circuit, are still Ohio state of Ohio bar union members. So we did a notice of appeal with the Sixth Circuit, and they have on 2 habeas. These were 2 habeas. We had a habeas for the mother, which is a special habeas. It's a Rule 35 kind of habeas, which is from a criminal side. And then we had an actual a petition of habeas corpus for the child, which was enjoined to the mother's criminal incarceration. And so they're both technically habeas corpus claims, and the circuit court has sat on it for 3 months. At least 3 months. I think it's more like 5 months at this point in time, because there's treason and sedition openly on the record. And they don't want to hang their own fellows. They don't want to bring in the military tribunals, which they're obligated by the law to do, because only the military has jurisdiction under acts of treason and sedition. Actually, if you title it that way, which is a barrier of law, that's a law definition. Now we have the capacity to put them to death under the 4th count of law by our law, but the military is supposed to do their job, and the judiciary is supposed to be referring. These trustees are supposed to be there, ensuring that these lower banks and administrators, these territorial administrators, are not in violation of international law, federal law, treaties, and statutes and administrative. They're in violation of all those. And when they're in violation, in as much as they're treated agents, they're supposed to refer them to the military for military tribunals. Mm-hmm. And they're not doing that because they know it's a can of worms and about half the judiciary could be hung. So with their flagrant, acts of child kidnapping in all of the states of the United States, the corporate United States. So, that's really where we're at. And so
what do we do where do we go from at this point to get remedy? What do parents...
Well, when we went to Indiana, it's basically acts as a second witness. And when we were able to move, we were able to move the case to Indiana, the territorial United States district courts are territorial courts. They are not the district courts named in the judiciary. And Title 28 actually exposes that within the administrative notes. I could get that for you, where they say they rename them. So they refer to the district courts of the United States. In Title 28, they say we now will call the classically known district courts of the United States to the United States district courts. So they basically created banks called the United States district courts versus the district courts of the United States courts. And that's exposed in Title 28. And those are, again, they're territorial administrative bodies that are supposed to be the top administrative bank for those territories to make sure that the bar unions are not violating federal law. So we went to the Indiana territorial administrative, trustee bank because the aunt, the great aunt of the child, who, as if you followed the case, was pre-qualified the day the child was seized to take custody of the child, was a tenant of the state of Indiana. So she could invoke that territorial body. Mm-hmm. So we moved over to the second territory, and they just didn't even look at the case. They just tried to convey immunity to the state of Ohio and all of their state of Ohio bar union brothers and dismiss the case. Well, and we used I used administrative process and basically brought a claim of equity upon them, and they have defaulted on a claim of equity. So when we appealed to the circuit court, because the district court failed to establish jurisdiction on the record, failed to cure the jurisdiction on the record, and instead just tried to dismiss the case and give the state of Ohio immunity, when we went to the circuit courts, we asked for another cure to jurisdiction, and they can't move forward without determining jurisdiction, and that's where we're at. We've put enough on the circuit court where the circuit court has now they first ordered briefing until I put some very keen and concise memorandum and brief, and then the demand for custody. We did a demand for proof of life, and we had to do some satisfaction of evidence proclamations, declaration of evidence, where we discussed, and I brought forth the state privilege clauses are subject to the laws of the United States and the federal common law. And so the administrator there has suspended briefing until the jurisdiction is determined. That's been 14 days. If they get past 30, they're going to look like they're in conspiracy to try to get out from under more treason.
And that's the Rucker-Feldman doctrine that you filed. Right?
I'm sorry?
Is that the Rucker-Feldman doctrine that you filed?
Yes. Yes. Well, the issue with the state privileges, see there, and this is where we're attacking both. Title IV is unlawful. It is unconstitutional in that Title IV has given the states of the corporate states, or even if they were the republic states, they've tried to expand the admiralty jurisdiction within the territories of the states, which is unconstitutional. The admiralty jurisdiction is exclusively a federal jurisdiction. By Title IV, they have tried to usurp that bar, that constitutional bar. The states are not allowed to operate in acts of rem or quasi-rem, which is acts of things, which tend to fall under admiralty prize seizure, like if you're going to seize a vessel, seize a boat, seize a car, seize a property, okay? Remember, they think of your children as property and vessels. They don't think of them as live, living, sentient beings with souls and rights or anything. And that's how they are able to treat you as a thing with a privilege and immunity versus a flesh and blood living man, woman, or child with substantial rights. So you're treated as a thing with privileges and immunities. Well, privileges and immunities are granted you by the state. Substantial rights are granted to you by birth, by landing, by your creation and incarnation, by your God, by your Creator. So they're denying you your God-given substantial rights by reclassifying you as a thing, as a property of the state. So the federal government, the corporate cooed federal government, which is cooed, it is being run by a criminal mafia at this point in time. I'm not saying everybody in it's a criminal mafia, but I'd say the preponderance of your federal government is a criminal mafia. They've been working on undermining our federal instrument since 1812. It's probably pretty thorough at this time, and you can see that when you watch the news and watch all the stuff. They're not applying the law. You have Mueller, you have all these people who are clearly committing crimes or in conspiracy with crimes and cooperating with people they're supposed to investigate. They're in conspiracy with people they're supposed to investigate. That's why you have a criminal mafia of international people from all over the world with their fingers in our federal instrument trying to steal everything that we own, including our children. So the federal criminal mafia in its designs to steal our children, being the sexual sadist cult that they are, created Title IV, which allowed the states to operate in acts of admiralty and rem and quasi-rem and seize them as things without due process of law.
Then we don't forget we have the bar. We also have the bar that is legislating establishment law.
Oh yeah, exactly. The bar is merely a tool of the criminal mafia. The bar unions are unlawful, unconstitutional organizations that are affecting RICO in violation of Sherman Antitrust Act. They are totally unconstitutional, and they are operating openly criminally. That is how they have locked up. They control the legislative branch. They are the preponderance of people in the executive branch, and they are 100% the judicial branch, quote unquote, of the corporate state. And those are the ones. The judicial branch. They have been using the judicial branch as the last bastion to prevent claims against their corporate state, and that's where they're at. We have them with their backs against the wall, showing openly prima facie, meaning on the face of the pleading and the facts of the case, that the bar union of the state of Ohio is an open conspiracy against the Constitution, is affecting war against the United States, is affecting open acts of treason and sedition. They need to be tried in military tribunals and hung for the crimes that they've committed. And they've committed against this child. They've committed against multiple child. This is not the only county where this rampant treason, sedition, and criminal activity and are being affected by the state of Ohio bar union. Okay,
no, it's all 50 states.
And they are just these people. And I'm not saying everyone that's in the bar union is a criminal, but whenever you know what's happening and you don't do anything about it, that's if I'm sitting in the getaway car, I get tried for the crime too, don't I? That's the law. Yeah, complicity. So if these people who are in the bar union, These people who are in the bar unions that are not openly acting against the criminals within their bar unions, they're complicit in acts of treason and sedition, and so that makes them traitors and seditious individuals. And ignorance of law is no excuse. And I get it. The attorneys that are against it, they know that they're going to be attacked. They know that they may kill them, that they may kill their family. Guess what? That's why you made the big bucks. That's why you make the big. So what they're doing is they're saying, well, I'm not going to put my family at risk, and I'm not going to put my life at risk, but I'm going to take the money, and I'm going to continue to operate in this bar union, which is a criminal enterprise. So in my mind, I don't care if you're openly, actively conspiring against the United States and acting in sedition and treason. If you're not openly against it, then you are acting in sedition and treason. That's the way the law works. So even if you aren't active and even know, I'm going to tell you, I would call an attorney, any bar union attorney that doesn't know that their unions are fraught with corruption, RICO, and criminal activity. I would call them a flat liar to his face, because I can see it, and I'm not behind the bar. I'm not behind the scenes. Okay. These people are behind the scenes, and they see judges being bought. They see the magistrates taking bribes. They know that the prosecuting attorneys are the key, that they are running the CPS agencies, that they are affecting child trafficking and selling babies. They know it. They know it. They decide instead to turn a blind eye and take their money home with them. Well, to me, that's just a criminal. They're getting paid blood money from a criminal enterprise. Okay? That makes you a criminal. That makes you a criminal, too. So you don't have to have your finger in that pot. If you take money from that pot, you're a criminal, okay? So any bar union member that wants to say, well, I didn't know, I don't care. You're lying. I'm going to call you a liar to your face, because they know. They all know. It's so rampant now.
No,
even people who don't.
They look at you like. They look at you, they take your money, and they look at you like, well, it was procedure, and the courts, it may be the law, but we have to follow procedures of the court,
Well, so what they're saying is we're going to, we're going to take your money and affect criminal fraud. I mean, that's constructive fraud. They're saying that they're saying, okay, and this is what you say when an attorney says that. You say, well, you know what? Your union's administrative procedures do not supersede the law. That's like saying, think of it this way. Think of the bar union as a corporation like Xerox with internal policies and procedures. Think of it like that. When you're hired by a big company, they have human resource procedures and administrative procedures. If you have a complaint with boss, or you get fired, or they put you under suspension, there are internal procedures that you would follow under the Xerox, right? Big multinational corporations, even state corps, any State Farm, name them. They all have internal administrative policies that you are to follow. Guess what? State Farm's administrative procedures do not supersede law. Neither do city codes and rules, because remember, cities, municipalities are corporations. Their municipal codes and rules do not supersede the law, nor do they supersede statutes. So the way the law works is it's the law, the common law, the federal fourth crown law that we established in the Constitution and in the Bible under Yeshua. That's the law. That's the high law. Then comes the state high law in their constitutional charters, which allowed them, you have to understand this, the state constitutions are what allowed the corporate states to actually have access to the federal trading company. The state territories, the Republic State of Ohio, was not allowed access to the federal United States Republic of America, that trading company, the United States, until it agreed to comply with the federal common law, the federal Constitution. So those constitutions are what they must comply with to even have access to our corporate charters, to the corporate Congress, to the corporate trading company. They're not allowed to affect trade internationally pursuant to the Constitution if they don't comply with the federal common law and the state common law affirmed in the Constitution. From those come the legislative statutes. Those are under, okay, so it's law at statute. It's not law. See, they leave that off. law is the high law. Law at statutes under that. Then come codes, rules, and administrative procedures. So when an attorney says, well, I took $30,000 from you, but, I know the law says this, but I'm obligated by the administrative procedures of the union, that's called constructive fraud and treason and sedition, because he's just agreed to conspire by taking money from you and conspiring against you. He took money from you and he conspired to follow his union rules, his corrupt union administrative bylaws and procedures, if he even did that, which they don't even do that, instead of complying with the law. But here's the deal. You privately contracted with him, so you agreed to surrender to their jurisdiction. That's why I keep telling people, you can never hire an attorney. The minute you hire an attorney, there's an unwritten understanding that you agree to surrender your substantial rights. You forfeit your substantial rights as a living flesh and blood man, woman, and child. And children don't have they're trying to impose it on children without any choice. Right. They're trying to they force children into that. They don't even give them a choice. So that's totally a constructive fraud. It's not even a willful execution.
They're also denying remedy for you as
and that's under Section 6. So all of these statutory courts, quote unquote courts, which are really at this point in time administrative trustees affecting bankruptcy. Since the bankruptcy and the Federal Reserve Act, since we've been under fiat money and we've been under the Federal Reserve notes, those statutory courts, which were created by the Judicial Act of 1789. And they have rules that the Judicial Act of 1789 is the defining creation of all the statutory courts, which now have been morphed into trustees under administrative international bankruptcy. They all have to comply with that Judicial Act. Section 16 of the Judicial Act of 1789 says that equity is barred when remedy at law is provided. So the minute that they violate the minute you are denied remedy at law by these judicial, quote unquote, courts, you then can bring forth that moves them to the claim in equity. That takes them out of their jurisdiction into our jurisdiction of the law. So they were given the privilege to operate in statutory forums in the statutory judiciary separately than the common law court. Okay, there's the statutory courts and the common law courts. They were allowed to operate in statute in commerce at this point in time, as long as they provided remedy and relief at law. The minute that at law meaning at law in statute. Okay, so at law is when they say we are in law. No, you're not. You're at law. That's why they're an attorney at law. The title attorney at law means you are attorneying at statute. Okay, you are torn at statute. You are twisting the high law at statute. They were given that privilege to try to expand, in particularity where things may happen, when things may apply, where the arguments should be looked at in a more particular fashion. But the way they're doing it is they're creating particularities to undermine the high law, to be exempt from the high law. So the statutory courts are only allowed to operate the way they operate as long as they provide remedy at law. Okay?
So, Lotus.
And remedy has to do with torts. Remember, relief is money. Mm-hmm. Remedy is tort. Relief is money. Remedy is tort. So when they fail to correct torts at law, meaning torts from acts of statute, when they fail to do that, when they fail to correct tortures upon the flesh and blood man in statute, in compliance with statute, then equity comes in. Mm-hmm. And when you traverse to equity, chancery's done. See, these are all chancery rules. And so we have a claim in equity upon the bar in the circuit court of the 7th district and, well, actually 6th district too. And they're trying to figure out where to take the case. Well, there's only so many courts they can take it to. Either they can affect jurisdiction, which they can't affect jurisdiction pursuant to the Judicial Act unless they send a writ of mandamus down to the district court and ask them what they exercise jurisdiction on. That's why they're kind of conspiring, because they can either take jurisdiction, and they know if they take jurisdiction, I'm going to make them put it upon the record. They can either then refer it to the Supreme Court, they can refer it to a military tribunal, or they can refer it to an international court of admiralty. Okay, those are the only three. Those are the choices right there. And the fact of the matter is a crime has clearly been committed against this child and this mother. And it's irrelevant how the perpetrators of that act are brought to justice. The child needs to be brought forth and returned to his family and produced live and well, like now. Mm-hmm. And that's what needs to happen. And barring that act, the United States, the federal United States, will be complicit in kidnapping if they don't do it, because they paid the corrupt state bar union to kidnap the kid. They've been paying the state bar unions to kidnap children since they effected Title IV and unlawfully extended the ability of the states to operate in prize capture, which is what they're doing. They're just going out there and seizing children outside due process of law. That's a crime. That's a crime pursuant to the Constitution. It's a crime international law. It's bond racketeering. And here's the paradox that they're stuck in. Pursuant to the law that's been well established in their own jurisdiction they're operating, which is admiralty, the states are barred from operating in acts of rem and quasi-rem, which mean acts against things or things that are attached to the living. Quasi-rem means things that are attached to living. So if you want to seize a car, or a house, that's quasi-rem act from a woman or a live person. They're only allowed to act like when they actually have jurisdiction over the res, the thing. Well, they don't have jurisdiction over our Social Security trust. They don't have jurisdiction over the Social Security card. They don't have jurisdiction over the Social Security number. The reason why they go and steal people and kidnap these children and kidnap you and put you in prison is so they can achieve jurisdiction. Mm-hmm. So the law is already established that the states can't act in admiralty unless they already have established jurisdiction over the res before they act. Well, they're going and stealing the children and stealing the mother and stealing your property and seizing it for the purposes of acquiring jurisdiction. So they're already openly committing acts of crimes to get the jurisdiction. That's established. That's established admiralty law. Mm-hmm. That was established by our country even in the throes of post-1812. These are case laws that were established under prize law and federal admiralty cases like in the late 1800s and the early 1900s. They are violating law that's already been established hundreds of years ago. Mm-hmm. They're just open. They just think that's why the Federal Reserve Act, they say that the attorneys are not allowed to cite any case law before 1946. You know why? Because everything they're doing now mm-hmm. has already been established as being a criminal act before 1946. So the bar unions are conspiring with the international bankers and the international criminal agents to undermine our Constitution, the treaties, and international law to steal everything from the American people. We're right back to 1776. If these judiciary do not do their job,
stealing and trafficking our children, but also effectively creating slaves, a slave.
They are slaves. This international criminal organization is professing to own you. And this is where they're doubly kind of screwed. They screwed themselves. In their federal student primer, and we've talked about this, it even talks about how children are treated in rem and quasi-rem probate. They actually specifically cite, that children are treated as probate in their federal student primers. These are the books that they provide to attorneys in their quote law school, which it ain't law school, it's banking school. They're basically banking administrators. In their textbooks for their law schools, they tell you that children are addressed by probate. And then the next section says, when you fail in jurisdiction, you go and seize the property to acquire it. Well, according to established procedures in the law and positive law under admiralty, states can't go seize things, the res, in order to acquire jurisdiction and then affect admiralty. It must have jurisdiction over the thing, the res, before it takes the act. Just like Sixth Amendment. The jurisdiction must be established upon the... That's in the Sixth Amendment, okay? So the states cannot go and seize a child in order to acquire jurisdiction. The states, and they can't seize a, quote, criminal. The mother, Ray, was convicted of a victimless crime. Actually, she wasn't convicted. She was forced to plead guilty to a victimless crime so that they could seize her son in an auxiliary maritime lien as a vessel, an attached vessel, like the dinghy of a big boat. So, or the keel, the prop, the stuff that's in the keel, the booty that's in the keel. So the child was seized as booty in an act of piracy by the state of Ohio, where they held the mother at gunpoint and then unlawful kidnapped her for a victimless crime, because the law says that you have to have a victim in order to have a crime. Well, things cannot be criminalized by men and women. So in the law, men and women have jurisdiction over men and women. Things have jurisdiction over things. The state of Ohio is a thing. It does not have jurisdiction over you. That's why they have to bring you forth as an all capital thing. So they're really screwed, because they're being exposed as having openly violated the law since like 1950. Okay? So pretty much everything that is hinged upon the Federal Reserve Act is a criminal enterprise and a conspiracy against substantial rights and constructive fraud. And so all the bonds that every fiat, let's put it this way, every Federal Reserve note could be junked from its inception to 1950 if we were to push this issue. And it really is at this point. It's not cured. That's why they're notes. A note is a promise to pay. Guess what? We're not going to pay them. The American people are not going to pay the debt of all the issuance that the fake Treasury has issued and told the Federal Reserve to print. We're not going to pay them. We're not going to if they're frauds. Mm-hmm. So when they close the Federal Reserve Act and try to take us back to the gold standard after they've stolen all our gold, no, we're not paying that. All these rich elite and the Pope and the Queen and all these world oligarchs that have stolen all that have hedged and have used all of our wealth to run their criminal enterprises, we're not going to pay for that. You can pay for it, and you're going to pay us for the constructive fraud you put against the American people. See, it's bigger than just stealing children. It's way bigger than stealing children. It's operating a criminal enterprise in violation of the Constitution and treaties established well before the Federal Reserve Act, and affecting constructive fraud against the American people by the issuance of bonds and notes, which are not lawful because they're not following the full faith and credit of the American people. They're not following our faith. They're not following our law. They're not operating in true faith and credit with the American people. They're not telling the American people that they're not your lawful government. They're not telling the American people that they're criminal enterprises. They're not telling the people that they've been cooed and that they're just mere administrators of a bankruptcy claim against us, which is fraudulent in and of itself. They're not telling the people that. So when they, as trustees, because your government is a trustee of the people, it was given trusteeship to run our government and to manage our states and shadows. Okay, that's what they're there for. So they're not the owners. They're not the owners of those shadows and estates. They're not. They don't have any ownership in them whatsoever, and can only achieve ownership by a cheat and theft. Okay,
so
they're supposed to make sure.
What would be the next thing that we need to do to get
a
military criminal tribunal? Because this.
Well, the next thing that we're considering doing in this case is we are going to go back to the administrative process. And as you know, I have yet to notice Trump or his Joint Chiefs of Staff blatantly of what is going on. And so we're going to notice them as to what is going on properly and bring forth the administrative process and put them on notice, just as I could put notice of the corporate Congress. They're not a Congress assembled. When you read paperwork, it's the Congress versus a Congress assembled. Those are two different bodies. A Congress assembled, quote, is a Republic Congress. The Congress is the corporate Congress. You know, these are the two pillars of our law. We have a Republic law and we have corporate law, which is founded upon and must comply with the Republic law. So the corporate law is not following the high law, and since it's not following the high law, we're not going to give you full faith and credit, and we can revoke your capacity to operate as a trustee. People have to remember, we can lay our government vacant by mere acts, in this case, of revoking the full faith and credit. We could say, you're not operating under our faith. When they're kidnapping our children, they're not operating under our full faith, are they? When they are denying due process to mothers and stealing children openly and willfully, committing acts of treason, suspending habeas corpus. See, here's the thing about...
If you recall the late Senator Nancy Schaefer, Wasn't she supposed to go before the criminal tribunal before her death?
Yes. So again, they already know. They've been since 2000. They've known since 2009 because they were noticed by a senator what was happening in Title IV. Okay, the military already knows. So you're getting to the point where your military, if after we know some, because I'm going to tell you, I've already noticed. I've actually spoken to, quote, the provost marshal's office in D.C., and the next time I tried to call back, they changed the whole queue because they couldn't believe I was able to get the actual office. So they're trying to insulate themselves. It's like, we don't want to hear the claims because then we're complicit. You know, an attorney never wants to hear what's going on. Let's put it this way, whenever I walk into one of their administrative forums, which is, you know, has pews, just a temple court, has pews in there. Those are church pews. You got a man up on the benches of Pharisees wearing a Pharisee's robe. Whenever I walk into those and I start speaking, all the attorneys that can get up walk out because they know that what I'm going to say makes them culpable in crimes. And if they hear it, then they are then knowingly culpable in crime. See? So they don't like to be noticed of the law because the minute you bring the law to them, when they fail to act in compliance with the high law, they become traitors and acting in sedition and treason because they're compelled to follow the law when it's put to them. And that's why they've given themselves this out in Title 28 saying that they don't have to be learned in the law because they've given them an example. We don't have to know the law to be an attorney. Mm-hmm. And they're telling you that they're not even exercising law. That's in Title 28. That's what I'm saying.
They tell you straight to your face. Oh, well,
right.
You know,
we're not exercising
and then
law
when
here.
You call them and you tell them the lie, they look at you and they say, well, we have to follow court procedure. And they just
no, you don't. Say, last I looked, you were standing on the Republic state of whatever, and you have to follow the federal common law. You're acting in sedition and treason. It's just like when the circuit court judge, and he's probably a very nice man, at least he's actually doing his job at this point in time, with the Seventh Circuit. He said he wanted a memorandum of brief. He says, tell me why I should look at all three of these proceedings and not just the last one, because there's three pleadings we put to the district court. And I told him, well, one, because let's put it this way, these are facts of law. If a trustee, an administrator, anybody operating under the color of law, who presumes to be acting in some type of judicial process, okay, or even an administrative trustee, anybody doing under the full faith and credit under Title 28, 1738, or 1738A. 1738A is for CPS and children. 1738A is all other acts. So anybody operating under the color of law affecting bonds or sealing documents under 1738 or 1738A, if they operate and they can't produce the jurisdiction upon the record that they operate in, or they can't produce the conclusions, law, findings, and facts, and they operate without establishing those things, that's an act of treason and sedition. So when a judge dismisses a cause of action without looking at the merit of the case and tries to convey immunity to the state of Ohio and his fellow bar union members from his associated state, and he can't tell you what jurisdiction and law, which they're compelled to do also in Title 28, when a judge reviews a case outside of a jury, he's required by Title 28 to put the jurisdiction upon the record too. Okay, so these are all things that are redundant, even with Title 28. When they do that and cannot produce the jurisdiction that they exercise, because you have to have jurisdiction to exercise the dismissal or to even do anything with the case, that's an act of treason. When an administrator operates without jurisdiction, it is an act of treason by established law, by positive law, by case law. Okay? So when these attorneys and stuff say, well, we have to follow the administrative process. Well, let me tell you something. When you follow that administrative process in your own little private bar unions, your little private hearings you're having down in these counties and municipalities, if you step outside the law, it's an act of treason. I don't care what your union says. I don't care what your magistrate or that judge on the bench says. If you operate outside the high law, openly and willfully, as an agent at law. It is a crime against the United States and an act of treason. If two or more of you, which meaning the prosecuting attorney and that magistrate or that administrator, quote, judge on the bench, cooperate, collude to undermine substantial rights or the privileges and immunities of your susdicate trust, which would be a construct on an international bond. If they conspire, two or more, high treason, which is an even higher crime, punishable by death. That's the law. Okay? So these attorneys that are saying this stuff, they might want to go learn the law because ignorance of the law is no excuse. And if you commit high treason in conspiracy against the law in your municipality by allowing this magistrate, which we have here, we have a magistrate who took a guy that was basically forwarding the cause I had with right to travel, and the administrator right out of her mouth said, I don't need personal jurisdiction over you to go forward in this case. That statement right there was an act of treason. When the prosecuting attorney allowed that statement to come out of that magistrate's mouth and allowed that hearing to go forward, which is a violation of the Sixth Amendment and everything we hold true in our country under due process, when they conspired to allow that hearing to go forward, it was an act of high treason. See, I don't care the law. I pity the fact that you call yourself lawyers, which they do in private, but notice they don't advertise as lawyers because they aren't lawyers. They're attorneys. That's why they can't advertise as lawyers. They don't have a doctorate in jurisprudence. They have a master's in banking administration. They're not there to exercise the law. They're there to exercise trusteeship over international bankruptcies, which our dollar bill is supporting. Our dollar bill, the Federal Reserve note, is a promise to pay for 147 nations who filed a joint bankruptcy. Do you understand that? So the United States dollar, the American people, are paying the bill for the bankruptcy of 147 nations. Okay? 147 nations put their gold into a trust fund, okay, a susdicate trust in the last World War, to allow a world organization to stop all, quote unquote, stop all the world wars, a unified economic policy, UCC, under the Uniform Commercial Code. Well, all they did, these world administrators, world bankers did, is steal all the gold. That's what all they did. That was the whole point of the gold. So
and now they want to openly traffic in our courts.
They openly traffic children.
Yeah.
They fraudulently seize people's houses. They fraudulently foreclose on people. They fraudulently steal cars.
They're talking about Sharia law. I mean, as if Admiralty law wasn't bad enough. I mean, Sharia law is like Babylonian slave trade. You know.
Well, that's all Admiralty. That's all Admiralty. Admiralty law is just piracy. Admiralty law is a law of power. Admiralty law is whoever has the biggest gun.
So we're going from bad to worse. But I have a question. Have you talked to Brian Kenter of the Judicial Accountability Movement?
Brian called me, and I've been so busy with this stuff. Brian called me about 2 weeks ago about looking into stuff in Ohio and some of these claims because what's interesting with Brian is his case with his daughter. His daughter's like really old, but he's still trying to get remedy for something that that happened, before she was 18. And he spent millions of dollars trying to get access to his daughter.
I mentioned to him, I think years ago when we started the PTJ and Jam about the going before the tribunal, trying to get something together. I was thinking of having him on the show actually. Maybe. Well, he is definitely well versed in Title IV, and he is well versed in, like with Ray's case. She has a situation with Title IVe and Title IVD. It's not just Title IVe that's the problem, which is where CPS seizures. They're using Title IVe unlawfully. There's only, we discussed, that when you go read Title IVe, there's only like 3 conditions or 4 conditions. They're also using it to profit off of child support as well. That's a whole nother racket. I mean, personally...
Totally. It's all that is, all they're doing, look, It's the same thing. What they're doing is the states are trying to acquire.
What I'm saying is they shouldn't be profiting off of child support. The federal government should not be involved in child support.
Right, but whenever you have set up, but whenever you have set up state corporate criminal enterprises, which are privately held corporations owned by the bar unions, everything that's under the state of is owned by the bar unions, okay? The state of is a franchise of the state, Ohio. So the state of Florida is a corporate franchise of the state, Florida. But everyone and so think about every corporation that operates in the state of Florida is franchised by the state of Florida. So every business franchise operating in Florida is a subsidiary of the state of Florida. Do you understand that?
Yeah, because they have to register with that state.
Okay. When they register for that franchise, they surrender to the private jurisdiction of the bar union of Florida. Okay? That's how they get you to waive your foreign state immunity and get you to agree to be within their private international criminal mafia private jurisdiction. You don't even know. So basically,
I would love to have a show with Brian Kenter, you, and Chris Hallert.
Oh yeah, I listened to a little bit of Chris Haller's that you did with him. Is that the one you sent me?
Yeah.
Yeah, I need to finish listening to that. But see, here's where they're really in trouble. Whenever we have the of Ohio criminal conspiracy, guess what? What does the 13th Amendment say about 14th Amendment citizens? It says 14th Amendment citizens have equal protection under the law, but they also have to comply. So that's in the 14th, right? You have privileges and immunities. The 13th Amendment says, however, that if you are found guilty of a crime, you can be made a slave or a peon. That's how you seize charters. Okay, so if the state of Ohio, which is a corporation, a United States citizen, all corporations are United States citizens with privilege and immunity. Xerox.
Yeah, and if you're not going along with their system, or you're unique in some fashion, then what they do is they have these state actors, these social workers that target you.
Right.
And they try to set you up in some way so that they can get you into your jurisdiction.
Exactly. So they can seize jurisdiction because the admiralty law says, and the equity law, and all law says, states can only operate in admiralty when they have jurisdiction over the rest. Well, the first 13th Amendment put that bar between them because the founder. This is the argument. They're going to try to say, well, allowing the states to operate in admiralty is an extension of the federal Constitution. Like, no. If the founders had wanted the states to operate in admiralty, they would have given it to them in the Constitution. However, the Constitution specifically gave the admiralty jurisdiction to the federal. You know why? Because they knew that the international bankers would try to break the United States up. They would try to break them up into 50 individual corporations, okay? So the federal construct, the federal Constitution prevents the international bankers from breaking up our union and creating 50 independent nations run by international bankers. Do you understand that? But that's what they're doing now.
With these
unlawfully
sanctuary cities. Oh, California, we want to break off from the United States.
No, you can't. Yeah. I tell you what, when the corporation of the state of California can pay for...
Here's the worst part about it. California... Jerry, I think it's Jerry Brown, they're openly saying, we don't want a middle class. We don't want a middle class. We want a poor class.
No, they want poor. They want poor and elite.
Class, so we can target and human traffic them, because when you create a poor, when you target an economy and you and you have a poor class, especially undocumented citizens, you have vulnerable individuals that are vulnerable to being human trafficked.
Yes, because immigrants are only given privileges and immunities because they are not nationals of the United States. They do not have, quote, substantial rights. But then you go to the Supreme Court, and the Supreme Court, this is the funny thing about our Constitution, and this shows you the coup. First off, let's call it what it is. That's called feudalism. That's called feudalism. Let's not change it to class argument. It's called feudalism. When you have a monarchy and vassals, that's called feudalism. So when you have an elite and poor, that's feudalism. So the governor of California is openly discussing returning to feudalism. Okay, that's what he's doing. So that's all he's a feudal monarch and being a criminal. That's all he's doing. So, this whole class discussion is the faux Marxism that came out of the second.
They don't want a economy that's thriving. They don't want a middle class. They want to
make you vassal. Right.
Yeah, it's
right. They want to go back,
folks. This is what I need people to understand. It is intentional that they're oppressing people in California because they don't want a middle class. They want the elite, they want the poor, and they want the undocumented because that is their apple cart.
Well, here, let's just this way. The state makes money on abject poverty. The state of the bar union of the state of California makes money on abject poverty. So that means that the construct that the state is there to provide for the safety, welfare, and freedoms and all the stuff of the people is antithetical, because when the state makes money on abject poverty, creating iniquity, let's go back to Aristotle, which is what statutes are there for. Aristotle named this in the Roman Empire the first time they pulled this crap. He said statutes are created by the Roman Empire to create inequity. That's what Aristotle said.
This is Machiavellian, if you ask me.
Yeah, of course it is. Of course it is. Of course it is. But about returning to feudalism. He's openly saying, so what the state does, and this is how the monarchs kept control of the people before, they keep the people in abject poverty and make them, eat at each other's throats for basic subsistence. That's what they're doing now. And now they do that, and they steal your babies while they're at it.
So
okay?
I would love, I'm just going to put this out there. If Brian Kinter, if you're tuning in, Chris Hallert, I would love to have all of us on live. I'm going to reach out to them because we need to.
I could probably call Brian. I could call Brian and ask if he wants to do it. I know Brian. I don't personally grow, but I definitely know of his issues, and we've openly talked. And I've gone with him to speak to federal reps.
Yeah, Brian and I are actually partners in the PTJ and JAM, which is the Portal of Justice and the Judicial Accountability Movement. So
right. That's how I know him. And how I know, I didn't know. Like Mike is Mike Galuzzo with National Organization for Parental Equality. He is also a good friend of Brian's, and I know that I knew Mike before I knew Brian. I met Brian through Mike. But I want to get back to this whole vassaldom thing, because this is where the United States and the Republic of the United States Republic of America.
10 more minutes.
Okay, I'm sorry. So what I want to say is that people need to understand that this coup, whole plot to undermine Republican forms of government, goes back to the Magna Carta. In 1054, Pope and four beasts, which are the four prevailing reeds of Prussia, Russia, pull them out, they conspired to do everything they could and created the Jesuit order to undermine all forms of Republican government because they wanted to keep the people in vassaldom. This is an argument that's almost 1,000 years old. And the founders of America, knowing, and this was in response to what Yeshua had done in establishing that main trust there, which we've discussed, the trust of Judas, which is from the 30 silver pieces. When he established that trust, and that trust was put into the land because they murdered an innocent man, since that time, these cults of Babylon have been trying to undermine our march to freedom from Babylonian slave trade. And the Pope has been lockstep in that since the creation of the Catholic Church and the Holy Roman Empire and the city and the Rome since they killed Christ. They murdered Yeshua and then through subterfuge,
Christ was really our advocate.
He is called advocate. He's called an advocate. He is called our advocate in the old tongues of the Bible. He was our counsel. He went to them as an advocate. Actually, they brought him. He didn't walk in. He didn't go and invoke them. They pulled him in there and beat him and then crucified him. Yeah. People have to remember, he wasn't crucified by having his nails stuck on a cross like that. The way he was crucified is he was bent forward with his hands nailed to wood so that he would suffocate. Okay, it's even prettier. They even make it prettier. You've never really seen how he was tortured by Rome. But in any case, the point is that in 1054, this cult of Rome created the Roman Catholic Church. And the Roman Catholic Church and the Pope and all of his minions and his ecclesiastic order of his monarchs and the Chancery, quote, law have been undermining, the other three crowns have been undermining Republican forms of government and set to task that since 1054. Mm-hmm. And in 1812, they tried to pull that coup with us because we barred them from our law. That's why the United States of America...
Again, people, folks, wake up. Please hear this message. Everybody, if you're tuning in, please hear this message. Lotus, you're on fire today.
Well, I mean, it's a historical. This is a long, drawn out, hidden war paper and subterfuge and treason and sedition and world people of power and money trying to undermine the common man's march to not be held as slaves. Period.
Yeah.
Okay. For every woman in
China, I'm putting it out there. Free. Next show, I want to coordinate you, Brian Kenter, and Chris Howlert.
Okay, I think that's doable. We might want to get a different forum on recording so that because when we're on Skype, the overtalk sometimes gets blocked out, and I think you want to have it so that all mics are live, and I think we can do that with another forum I'll talk to you about. But people have to understand that this is not something that just happened in the last 50 years. Yeah, but everything that has happened is a long process of meticulous steps to undermine the law that Yeshua established and that we put into writing. This is the beauty of the American construct. We put the law of Yeshua into a document and put it in paper, and we spelled it as law of the Creator. When we did that, we put the nail in the coffin of the Pope and the cult of Rome and their monarchy and their Babylonian slave trade. And they have tried to undermine that declaration, that separation of the fourth crown of law, which is the highest law of our existence. Mm-hmm. The fourth crown of law is the law given to us by our creation and incarnation, that all men are equal. There are no monarchs and kings at birth. Yeah. Those are fictions of men and women, and they are fictions of men and women and malfeasance who think that they have the power over another man. That is a corruption of mind and spirit, to think that you are the master of another man or woman or child against their will. Okay? That is what Yeshua said. That is what Yeshua established. Rome is not, you're not my government. You're not my father. Pharisees, you're not my government. I have a higher father. I have a higher kingdom. My kingdom is higher than yours. You're men. This is Creator. So he established that, and we affirmed it.
I am a creator.
Right. We are all given the rights of the Creator. We're all given equity under law, and the Bible speaks specifically of the iniquity of men. Reprobates create iniquity. Publicans create iniquity. Publicans, not Republicans, publicans. Look in the Bible. Publicans create iniquity.
I'm going to be live at 3 a.m. in the morning on the Zeph Report. I'm going to be binding these reprobates, binding them to hell.
You should bind them. Not that they are bound to hell. They are bound to hell. Look, we're going to win the argument because it was already won a long time ago. It's just routing out the hidden evils that exist in this realm.
No, and we need the consciousness to understand, to really understand.
Right. Exactly. People have to be conscious of the fact that what they're seeing is a ruse, and they have to lie to us. See, and that's the thing. They have to lie to us because
they didn't come out and just say it straightforward what they're trying to do, and not under the guise of it being like, oh, we want equality and Sharia law and women's rights and transgenders.
What all that is anytime. Okay, it's the concept of privileges and immunity.
Multiple genders and all of this stuff. It's not housed never mind. I don't want to go into that topic right now.
Well, anytime you sit and you say, okay, first off, the concept of civil rights is a fraud in and of itself, because when the women were given the civil right to vote, and because, as you know, I'm real, people say, well, the word, all men are created, well, the word men, well, the word men is in woman, so they mean both, okay? So there's only men, only white men have the right to vote.
I meant by when I said transgender, I meant that they were trying to create a third gender so that they can supersede these laws. They're trying to do everything that they can to work outside of the Constitution.
They're trying to create special classes by statute. That's what Aristotle says.
Yeah,
Statutes are there to create iniquity. They're there to create a type of administrative law.
And I don't mean that like in a negative way, because I love my transgender friends.
I know, but no, it's not a negative thing. But being down a paradox, okay? Yeah. They're being misled. So Aristotle says that statutes are there to create inequity. Okay, hold on. Let me get to the second part of that sentence. Let me get to the second part, because that's the important part. Aristotle said statutes are there to create inequity so that the prevailing state of men in their corruptions can apply those statutes in particularities and particular states of people and men in inequity. He's saying that the statutes, when Rome brought the statutes in, they were saying, oh, we need to bring these statutes in because, you guys over here, you're this religion and you're from this culture, and so we're going to allow you to do government. But really all the statutes did was allow the overseeing government to oppress this region and give that region special privilege, or oppress that man but give that man a special privilege. They're there to hide the iniquity, the arbitrary and capricious application of privilege. Okay. So that's the problem with statutes that have never been brought in compliance with the high law.
Talking about, if I may digress, that's what I was talking about with the bar legislating law, like establishment law. All of this is to legislate statutes illegally by way of the Bar Association, who, by the way, is not supposed to be able to legislate law. They're there to enforce the laws, but that's not what they're doing. They're being complicit.
They're not even there to enforce the laws. They're barred from the law by the original Tone Amendment. They are not do anything but to administrate estates and trusts and chattels in compliance with the high law. That's their mandate. That's not what they're doing. Instead of administrating our estates and chattels in compliance with the high law, they're abusing statutes. They're not even complying with their own statutes. They're not in compliance with Title 28. They're not in compliance with administrative policy or code or rules or anything. No. They're just rampantly, openly criminals. Mm-hmm. They are rampantly, openly kidnapping children, denying, in this case, with Clay, they have no discovery, they have no transcript, they have no warrant. How is there a child kidnapped for almost 3 years?
Yeah.
How? Explain that to me.
Well, we need proof of life. We need that.
And we have 2 district courts and 2 circuit courts and no live child. We don't know where the child is. We don't have proof of life. When you have no discovery, no transcript that's able to be produced by a notarial officer, and no warrant for the seizure of the child, how is the child missing for almost 30 months? Tell me that. Yeah. Except through criminality and conspiracy to perpetuate that criminal enterprise. That's what's going on rampantly every day, multiple times a day in this country, in every state of this, quote, nation, not country. The country is the land and the people. The nation is the corporate state of the federal franchises, the bar union corporate franchises. Well, you're being oppressed by fascism. It is.
Yeah, you know what? You're absolutely right. We're at the bottom of the hour, and Lotus Justice is the modern day Joan of Arc in that spirit. Lotus, thank you so much for coming on.
Well, thanks for having me. I'm glad I was able to update people. We're gonna bring the military tribunals in, and if they won't do their job, then the people will do it to the military as well. And if they want another 1776, it's not going to be pretty this time. And that's what we're trying to prevent. So I certainly hope that the people who are not reprobate and not, as we've said, there's only 2 sides of the argument. Either you believe that children can be stolen and kidnapped and made slaves along with people, or you don't. Either you believe in slavery or you don't. Because right now you have a state of international and national and state criminal mafia making people slaves. treating them as modern-day slaves. This is old Babylonian slave trade. Stealing children without due process, without true evidence, with no crimes, with nothing. Just blatantly just kidnapping children. The judiciary, judges, prosecutors, sheriffs, and cops, CPS workers, stealing and kidnapping children as of the state.
We're going to be praying tonight on the Zeph Report. I'm going to be praying, we're going to wake up the minds. We're going to get this in the consciousness of the people, and we're going to be fighting the good fight, the people that are against slavery, against child trafficking. It's done. Right. So, listen, this has been awesome, and I want to have you on with Brian Kenter and Chris Hallert, so put the word out.
That sounds awesome. Remember this. We're the armor of God, and we have God's favor. You remember that. We always have God's favor. The righteous always have God's favor, and everything you do, know that you wear the armor of God. Amen. Always remember that.
Amen. All right, guys.
I love
you too, Miss Lotus Justice, everyone. Oh, she is awesome. All right, so that was another episode of Porthole to Justice, the window to the truth. Hey, guys, share this episode. Subscribe to the Porthole to Justice and share this with your friends and family, because we really need to educate and wake people up. It's that time, folks. So, yeah, tune in. You can find me on Facebook, Porthole to Justice. You can also find me on Twitter and Instagram. I'm going to close this out with a Zeph Daniel song. It's called The Coup Against the State. Oops, what happened?
I don't know why you thought you would keep on. Now that everybody knows, from your head down to your toes, you really did wrong to lock me up in the asylum. You knew I'd get out one day. Yeah. You knew I was coming after you. You knew one day I'd settle the score. I don't know why it's so quiet here, but yeah, you've done me solitary confinement is not meant for me. The Thorazine and all the medication made me into a zombie. I don't know if I'll ever get over it. I use my psychic power to track you down, and I tracked you down. I tracked you down. You seem to think that I won't ever come back, but now that was me you waved to on Sunset. I saw you there. Slim old BMW. And Lida Whittier going to check on your mom's house. Don't think that I forgot for 1 minute how you delivered me up to Satan. And I did object because I'm not just like you. I have a point of view. You have no right over my soul. You have no right. I know you're mind controlled and your soul is gone. I know you're just a servant of darkness. not tell me you had set me up at night? No, you and them all, now you're old, you're withered, you're ugly, it's all gone, you're not sexy, you're stupid. I don't know why you thought you would keep on. Now that everybody knows how you delivered me up to Satan. You really did wrong to lock me up in the asylum. You knew I'd get out one day. You knew I was coming after you. You knew one day I'd settle the score.